possible to win in family court? You actually have a better chance in criminal court, a court that may be more interested in your evidence. Can you win custody? Can you successfully get a downward modification? Can you avoid a contempt proceeding? These and similar questions are what litigants need to be answered in court. Today, the President for Americans for Legal Reform, Gary Jacobs, will help you get to an understanding of what transpires in court, if you will listen. But remember, the scales of justice are not tipped in your favor. How's that?
That's a lot. You got a lot of good information to come. Take out your notepad if you're watching.
Okay, Gary, let's go. Let's have a rip. See, winning in court is the topic of the program. Is it possible?
Well, first of all, when you say the topic, when you say, is it possible to win in court, that should be in like these little air quotes, because there really is no winners in court. The only winners in court are the lawyers, and I guess the judges, because it keeps feeding the monster, and the jails and the court officers. But there is no winning otherwise, because even a win, many times a loss. You mentioned custody. Well, who wins? If the mother wins custody, what happens? The kid just lost half
the kids become the losers.
The kids now don't see their father, 80% of the time. If the father wins, they don't see the mother. So really, there is no win. The win is staying out of court and coming up with a settlement that's in the best interest of the children. But anyway, I just had to get off. I had to get that off my.
No, that's okay.
Get off my shoulders.
That's very important. Now, you can always go to mediation, which will avoid all the crap.
And then you can win.
And then you do.
When you're in court, there is no.
It's a double win. Win-win.
Right. If you go to court and you win custody and you spend $70,000, is that a win? Is that you make it custody, but $70,000 is a lot of money.
Sure.
And I think they say on Long Island now, a contested divorce with custody, and then all the orders of protection that go with it, costs each litigant around $100,000.
And that's okay. That's an average.
Each litigant.
Really? Okay. And that's a little higher than I thought it would be. And then also on top of that, you have the loss of someone's going to lose, and they're going to lose custody. I mean, no offense.
And they're paying the money, and then you have the law guardians that you're paying, and then sometimes you get to pay a forensic psychologist for another $15,000, and experts. So this is a lot of money. Yeah. And even if you win, what happens? Now you just spent your life savings, and your life is destroyed.
While we're on a roll about the advocacy and the money in court and everything, what about hiring a lawyer? Are they really the advocate that you think they are?
Sometimes lawyers are a necessary evil, because unfortunately it's easy for people to say, who have been in the system for a long time. They'll go to the litigant and they'll say, listen, go pro se representing yourself. Screw the lawyer. You don't need to pay him that much money. You know your case better than everybody else. Well, that is true. You do know your case better than everybody else. The problem is, by the time you get to the point where you're knowledgeable enough to represent yourself, you're done. You're fried. Your case is over. You can't. Most people who go through a divorce, like me, and probably like you, had never been in court in their life before. I had never, maybe I got a ticket a long time ago, but I had never been in court.
Right.
So this was all new to me. I didn't know how the whole thing worked. It took about I would say 6 or 7 years of me being in court before I got knowledgeable.
We always say they build the courts and they will come.
So I'm there now. I know how to do it. Now, yes, I could do pro se, but there are a lot of problems inherent with representing yourself. Number one, advocating for yourself is difficult, because if you're a woman and you advocate for yourself, you're a bitch. If you're a man and you advocate for yourself, you're an aggressive prick.
You mean the perception
to the court.
Right.
It reminds me. Recently we had the hearings for Judge Kavanaugh, and without getting into politically which way I believe in, but he was put in the position of a pro se litigant, because basically he was representing himself to try to get in, right?
So the woman,
so the woman accuses him of doing these things 30 years ago. He says he didn't do it. Let's just say he didn't do it, and the woman was mistaking identity. Now he's pissed off. So he's getting up there and he's making all these statements and he's getting aggressive. And
well, he should.
Because he's being accused for something he didn't do. So now they're saying, this man, look at him. He's so aggressive. He doesn't have judicial temperament.
Right.
Well, now if he went in there and just sat back and let the woman talk and said, maybe she misunderstands, what would the pundits be saying? This man, look at him, he's guilty. Yeah. He's not sticking up for himself, he's just sitting back. So it's a lose-lose situation. But a lawyer can advocate for you. But going back to your question, are they your advocate? Well, they have dual loyalties, the attorneys. Right. They really do have a dual loyalty, because at the moment, yes, they're supposed to be your advocate and be loyal to you.
Right away, that doesn't work for me. I'm just saying. I mean, I'm going to hire somebody who's going to, have some kind of influence with the judge that he's in front of. Also, some kind of interest in me, and also in
Well, I'm
himself.
saying that there's dual loyalties because there's triple,
himself.
tri-loyalties, you know. But they're supposed to be your advocate, zealously advocate for you, all that bullshit that they teach them when they take their hypocritical oath or whatever they take, you know. But the truth is, when you're done with your case, either because you run out of money, you go to jail, or you give up, they move on to the next client. They got to see that judge for the next 20 years of their career.
Which is where the third party comes in.
So
they have to take care of
you know,
themselves.
how many times have people come out of the conference and said, "Oh, the judge told me he wants you to do this." I don't give a shit what the judge says. You're my lawyer. Tell me what's in my best interest.
No, exactly
but they
right.
don't, because they don't want to go back to the lawyer and go, "Hey, I couldn't convince my client to take that bad deal, judge." So then they push you.
That's funny. That's exactly what my attorney said to me. You got to sign this.
I hear
He
it all
even
the time.
turned his head. Here, sign this. The judge is going to be mad at you. He didn't
Right, the
look
judge
at
is
me.
going to be
He
mad
didn't
at
even
you.
look at me.
Yeah. Well,
Yeah,
the
you
judge.
know
This
why?
is what the judge
Yeah.
wants. What do you mean the judge wants? Tell me what's right for me, you know, lawyer. Tell me what's in my best interest. Doesn't happen now. That's why advocates, which is what I do, which is what you do at Americans for Legal Reform, an advocate is good. I have no financial interest in this. Americans for Legal Reform has no financial gain, and you need somebody there who's advocating. And you know, even
Now that's an advocate.
Even some of
Who
the
doesn't have any financial gain.
Even some, you know, the women's rights groups. There were more of them. There's not as many. But when they go there, I don't always agree with them, because I think a lot of times they take somebody who's not actually a victim and
Make them a
that's
victim.
another whole thing.
Yeah.
But they really do advocate for the person, because their interest is they want that person to either
At least they
find
can
the
be
other person.
called an advocate.
They really are an advocate. A lawyer is not really an advocate on Long Island, I'll say, because here is where we have this old boys network, you know, where they're all in bed with each other.
What about signing stipulation, and can we defer to the judge? That was a question. If you're given the chance to sign or stipulate, can we defer to the judge?
Well, here's what I tell people. If you want to go back to court, I mean, we're gonna get to can they change. But first of all, what can you change? What? There's two different things you're talking about changing. Are you going to go in and try to change a stipulation, which means that both parties agreed and they signed it? And sometimes, usually, if it's signed in court, then that will become a court order, because you'll do this handwritten stipulation. They'll go to the judge will stamp it and say, now it's ordered. Or you get an order that was done at the court. You know, you went to trial, the judge made a decision, there's a finding of facts, and now you have a court order that was rendered at a trial with a finding of facts. It's easier, much easier, to change a court order that was ordered after a trial with a finding of facts than it is a stipulation.
Is that a change of circumstances?
Well, because you can go in and say let's just start off at the beginning. We're talking about a downward modification. That's very common now, because the economy isn't great right now, right? People aren't making what they made 10, 15 years ago. So a lot of people, even 5 years ago, and different, not only because of the economy, but because the economy is changing as, you know, technology is becoming more important. Blue collar jobs, many of them are going away. Manufacturing is going away. So you may, at no fault of your own, be all of a sudden making a lot less money than you made, and you're 40, 50 years old, and you got to reinvent yourself. Not so easy for a 50-year-old to go out and get a job making the same thing. So a lot of these people went and they had a stipulation that they agreed to when they got divorced. Okay, I'll pay $2,000 a month. Well, now they go back to the court and they say there's a change in circumstance. My company moved off of Long Island because the taxes are too high and they couldn't afford it, and they gave me 6 months severance, and now I'm out the door and I can't find a freaking job at 55.
All the people that got divorced after Grumman left with 60,000
Exactly.
employees.
So now now they go to court, and the judge says, well, sir, look, you signed the stipulation, and there was nothing in here that it was based on your income. You agreed, and maybe you were given what we call consideration, where you got something in return. So no, I'm not going to change it, because this was anticipated. Where if there was a court order at a trial, the order would say, you know, Mr. Jacobs at the time of the divorce made $150,000.
And now?
Mrs. Jacobs made $50,000. Her share should be this. His share should be this. And that's what I'm basing my decision on. Well, now if you can go in and prove that, well, one of the steps, I'm going to get into the other steps. One of the steps is, first of all, to prove that you are making less money. Okay, well, the agreement was based on 150. I'm now making 75. The agreement needs to change.
And that by the way, doesn't always work because I did that for myself when I went through my divorce.
Yeah, it doesn't always work.
No,
but it does work if you do it the right way. Most people go in with the wrong way.
In my case, they averaged the income when Grumman was available to me because I had an industrial supply business. I was making money off of the ancillary companies that provided for Grumman too. So I had a big circle of money. I lost half my income in 1991, for instance, when Grumman left. But the court said, no, Mr. DiMaggio, you're capable of earning over $100,000
they do the imputed income.
Yeah.
Well, that's another whole problem,
averaging.
but that's
well, it's a part of this. I mean,
yeah. But one of the when you go in and say I made less money, and people come to me,
it's not fair. That's for sure.
Well, a lot of stuff's not fair here. We talk about fair, we can't even talk about in the same sentence.
We're in the wrong place right now,
with court system.
Yeah.
But when people come to me very often and they say, I don't understand this. I went to court and I told the judge and I showed my taxes, I showed my W-2s, and I proved that I'm making less money. And I go, and you're going to lose 100% of the time. 100% of the time you're going to lose. That's only one part. The second part is, did you try to get a job where you could earn more money? And prove it. Now, people also tell me, well, maybe I did that. I went and I told the judge, I went on Monster.com and filled out 50 applications. Well, pretty self-serving. You're the one who's looking for the downward modification. That's not proof. That's you testifying, and the judge can consider it.
That's for
so,
sure.
What you need to do is, number one, prove. When I say proved, that is not you. I say everything that you're trying to prove and get the judge to believe should be done through a third party or through evidence, not your testimony. Your testimony's shit. You're the guy, you're already going in there, and you're the asshole who's just trying to pay less money. They're the deadbeat dad. That's the way the courts look at every guy
you can give
who goes to court.
That's authorized or backed up and
you can give it, but it means nothing. Support it with other things. So what I mean is, first of all, prove it. Bring in your accountant. Bring in a financial expert. Then prove that you've been looking for a job. But really, you have to look for a job. Bring in a whole stack of papers of every job for the last 6 months that you applied to and what they said. Wow. Subpoena some of those people to come in. Fuck them. Subpoena them. Send them a subpoena. Did I go here? Bring in an expert in your field.
Oof, that's a lot to do.
You're looking to get. There's people who are paying thousands a month more than they can afford. And remember, the courts have another interest. Their interest is to. This is great for them. Not only we don't reduce it, that they let it stay up so it accumulates debt.
Stay in business,
and now you're in arrears. So now the state collects more money for every dollar they collect. And even better, you don't pay it. Now we get to put you in jail. That's a great situation because now you go to jail and we get to keep the jails filled up. We get to keep the prison guards all get to have their job. The counties have everybody's
the expansions in the parking lot.
Yeah, exactly. Everybody's happy. So you have to go in and prove that you tried to earn it, and then you have to prove that there's nothing else that you can do because they're always going to say, well, go work here, go work here. You have to prove that you tried and that there's nothing. And there's experts that do this.
I know you're right about this, but I don't like
the idea of it. But you'll win it if you do it. Honestly, unless you get a piece of shit judge like Aletha Fields.
Attorney doesn't know you can do
well, that's a
something
different
like
thing. But there's some real piece of shit judges. Aletha Fields, not even a judge. She's a support magistrate, an affirmative action woman who was thrown in there. You know, she's totally unqualified, nasty woman, and you're not going to win in front of her. But listen, people say all the time, I know I can't win in front of this woman. Go do it for the appeal. Preserve the record so that you can appeal it and say, I proved that I don't have the money, that I tried to get the job.
That far ahead. I agree with you.
But they have to, or they're going to lose. That's why we're doing the show.
That's why we're doing the show.
Hire the proper attorney. And listen, if your attorney says, I'm not doing that, get a new attorney, fire them. They work for you. And don't think that attorneys, number one, are all great, because many of them suck. You know, number two, that they're always looking out for your best. You're nothing to them when you go in there.
They should know that they don't specialize too. People looking for an attorney, not every attorney is specialized in family court.
Or know how to, let me tell you, there's an attorney that I recommend a lot of people go to, Robert Hiltzik. He's in Jericho. And he tells, when you go in there, if you go in there and say, I don't have this track record of looking for a job, don't tell me I did. I don't have proof that he'll say, don't waste your money on me because I know you're going to lose. Come back to me in 6 months when you've tried to get another job making more money. Otherwise, you're going to get the money imputed to you.
What about, because it was imputed, pendente lite applications, stopping, causing a certain amount of money that has to be immediate to take care of?
Well, here's the problem. Pendente lite is an order that when somebody first files for divorce, and I'm not a lawyer, so I'm just giving my layman's terms. I'm sure I failed Latin in school if I even
litigation.
Took it. But pendente lite is basically a temporary order that wasn't done at a full trial, but it's like, let's just say the husband's making a lot of money, the wife wasn't. they know this divorce is going to drag on for a year, 2 years, and she can't be like starved out of the house and have no spending money. So the judge issues a temporary order. These are very important because they set the groundwork for the rest of the case.
Right.
So
you
if the
have
judge
to win that because that's exactly right. You
Right.
can sometimes get pinned down to a pendente lite
Well,
application.
there's several things that first, people go, oh, the lawyers who are the bad lawyers will say, don't worry about it. It's all subject to reallocation at the trial. It's only temporary. Don't spend a lot of money. Bullcrap. It puts the footprint on the case. If the judge orders you to pay a high amount and you don't pay that amount, you go to jail for contempt. If you do pay the amount and now you go to a trial and they go, well, we want him to continue to pay $4,000 a month, and he goes, I can't afford it. They go, well, of course you can afford it. You paid it for the last 2 years, so you're screwed with that. So pendente lite has to be. You have to
Address
fight,
right away.
address it.
Right away.
And here's the key also. If it's a pendente lite is too high, which in Suffolk County, many of them are, because it's to try to way to stick it to you and make you settle.
Right.
But let's say you're the wife who has a great pendente lite.
Make you fight for a downward modification later.
Right. But if you're a wife who has a great pendente lite, paying you more money than you know you're going to get, well, you're not going to move to trial very fast, right? Because you're getting more than you're going to probably get after the trial.
Yeah, sure.
So now you just keep telling your attorney, hey, just keep getting adjournments and take it. And you could easily, in Suffolk County, stretch it out for 3 years, sometimes even more. But easily, you could stretch out a divorce before they get to equitable distribution for 3 years while you're getting all this money that you shouldn't be getting.
So how do you spell a quick response to the pendente lite?
Well, first of all, you got, if you have it bad, but
To-
you
to
put
win that
you put in the
particular
fight
point.
right off the bat. They're hard to change. I wouldn't even recommend filing an objection to change it because the judge is just going to say, listen, you're going to get reallocated equitable distribution. We'll deal with it then.
That's
but if
not good enough. We know the history behind it. So can we tell people what we know?
Well, what you have to
It's
do
gonna
is
stick.
If
It's
you
gonna
first
stick.
of all you fight, it's going to stick. Don't believe your lawyer. It's going to stick. But fight it hard at the beginning to get the correct amount for the pendente lite, number one. Number two, if you get a bad pendente lite, don't let your lawyers bilk you, because don't believe this crap when the lawyers go, oh, there's nothing we can do, it moves slow. No, that's not true. There is something. Listen, you can't move it. You can't say you're not entitled to a speedy trial like you are in criminal cases, but you can move it along very fast. A 3-year case is because someone's dragging it on. So what I tell you, tell my lawyer to go in there right away, set a schedule. Okay, this week we're going to set a schedule for discovery, set a schedule for depositions, and then plan a trial for 2 months from now. And ask the judge, say, Judge, my client's ready to go to trial. He does not have a lot of money, and he wants to go to trial as fast as possible. I'd like you to mark it final for 4 months from now. Can we mark it final where there's no adjournments? Can we all agree to that? Now, the other attorney doesn't want to agree to it because he's not going to get a lot of money. But what are they going to say? No, I don't agree to
He's
that.
gonna
Well,
feel
why?
squeezed. Yeah, because you're giving him
Why?
all the reasons to settle.
Right, because
hey,
listen,
I'm ready to settle.
your
What's
own
the story?
attorney, if you have money in the bank,
I got it.
your own attorney, for the most part, is not going to do this because
Right.
they want to. You fill out your net worth, and he goes, this guy's got $100,000 to
So what if
spend.
you don't get that far? I mean, it's a good idea, but what if you don't get
Well, listen, you control the attorney. The attorney works for you.
This is a win too, folks. For those
I hate
people
when people
listening.
tell,
Yeah.
listen, you got the
it.
internet now.
Yeah.
Google is great. Go to Google Scholar. Just go to Google and type in New York State rules of evidence or whatever it is. And if your lawyer is not doing something, for example, subpoenaing somebody, fire him.
Yeah.
First of all, I want you put it in writing and you document it. You write them. Why aren't you subpoenaing X and X to prove my case? I Googled it, and it says this is what I need to prove my case.
The only place that would be a problem in terms of hiring another attorney is you have to give some consideration for the lower threshold income litigants who may not be able to jump around. Well, I got this. I didn't know I gave
Listen,
the $5,000 for
right.
the retainer here, and now
I'm
we're going
not
to
saying
come up
it's
with
a-
another $5,000.
Listen, it is a problem, but what happens is, if it goes on, people let it go on too long. If it doesn't feel right, get out. Get out and get another attorney. Go to an advocacy group and ask who they recommend. Get out. Do not stick it on because it's only going to get worse.
Right.
It's not going to get better. But demand that they do it.
Okay.
And document it.
That's
because
another way to win.
Let me tell you, lawyers know documentation because when they go to court,
That's what they
people
use.
document on the record. You object because of the record, right? So send your lawyer an email. Don't say it in person because he doesn't know if you're recording him or not. So send him an email and say, Dear, John, you said I don't have to subpoena these records, but I Googled it, and it looks like in order to prove my case, I need to subpoena it. He knows that now he's setting him up for malpractice if he says no. Now, I don't know why some lawyers don't do these things. Is it because The judges don't listen. Judges don't like expert witnesses.
They don't like smartasses either.
You know, they don't like all this long testimony. It makes the decision a lot harder because they have to make a finding of facts. If you just put in two people to testify, and the judge doesn't like you, man or woman, you're the designated loser. They do what I call self-directed verdict. The decision was made at the beginning, and the trial is just taking notes to use the stuff that they're going to use against you. But if you put in hard evidence, proof, documentation, you make that judge's decision very hard. A lawyer, Bob Del Cole, on Long Island, once told me, they're going in it to screw you. You have to make it impossible for them to make that decision. You know, even in an appeal. People look at the appeals and they go, oh, I'm right. Listen, when you write the appeal court is looking at it to look at what can we do to throw this appeal out and protect our buddies. They're not looking at it, let's make sure that there was no injustice. Let's make sure the Constitution.
And the overturn rate is like 3 or 5%.
You know, some people say 2, some say 10. But let me tell you, they're certainly not looking at it with the eyes of making sure justice. People had justice.
Let's go to describing constructive emancipation. You had mentioned.
Right. Well, constructive emancipation is, you know, a lot of times, as you know, I'm very involved in parental alienation when one parent turns a parent against the other child. And what I say all the time is the only thing worse than having a child turned against you is being turned into an ATM. That's a really bad feeling when all you are is an ATM handing money for kids who don't talk to you. How do you get out of this? But in New York State, the emancipation age is 21. Most states it's 18 because that's when they can make their own decisions. In New York, it's 21, but on Long Island, 21's not good enough because we want to get money for a little. So we say it's going to be either 22 or until they graduate a 4-year college or they turn 22. And trust me, try to go in at 21 and a half and your kid's not in college and try to get it cut off. The judge, you got 6 months left, or they'll just drag it out so you keep paying. Constructive emancipation is when you go in and say, to no fault of my own, my child isn't talked to me. It's due to the mother. It's due to the father. But again, you have to prove it. You can't just go in and say it because they're going to say, "Well, it was your fault that they don't talk to you." So if it's parenting time, you have to show up every single day on your time. I don't care if the kid doesn't come. You show up. You text your spouse, you text your kids, and you take a picture and you document that you're there. And you do that for months to show it. You text every day, you call your kids every day, you send emails, you try to suggest therapy for them. Because then you're showing that you did everything that you could to make this relationship work, and at no fault of your own, the kid's not talking to you. And that's still a tough win, though, to do. That's a tough one. Because remember, the state doesn't get the money if you stop paying because of emancipation. There's very few judges here that have the balls to do the right thing.
Do we have in Americans for Legal Reform the 1, 2, 3 of some of these things you're bringing up now? Because I think it's something, if we don't already have.
Well, we don't have them writing. We don't give legal advice at Americans for Legal Reform, but we do help members and try to guide them in the right direction, and they can hopefully learn from our.
To things like this show.
Right. Well, somebody would come to me, and I would say, hey, go to Chris DiMaggio's show. He did a show on this where I spoke, and take that. We also help, just having, as you said, an advocate there. Many lawyers, there's a guy, Robert Garcia, an attorney here, who's obviously knows that he's an incompetent attorney, in my opinion. And when I go to sit there in a meeting as an advocate, I don't want you here. Well, why? What are you scared of? It's like a camera in the court. What are you scared of? Do the right thing. You should have a camera. So bring in an advocate to your attorney. Let your attorney know that I have an advocate involved in my case.
That reminds me of the court watchers. How do we make a good representation for court watchers?
Well, court watching is not always the right thing to do. You escalate things, like a policeman. They're not supposed to. We're in Suffolk County, got to be careful. But they're not supposed to just go in and escalate a situation. They learn how to step up the levels. They don't just walk up to you and tase you and handcuff you. They escalate things. So in court, I always give the judge the opportunity to do the right thing first. Somebody comes to me and says, I'm going through court, I heard Suffolk County, Nassau sucks, and I'm really worried, I need court watchers. I say, no. Go in there and give the judge the benefit of the doubt and see if the judge does the right thing. If they don't, then bring in court watchers. If they don't, then bring in Americans for Legal Reform. If they don't, then come on a TV show like Long Island Backstory, which I hear is a terrific show. But then come on your show, then come on my show, then come on radio shows.
I forgot to mention that you're the producer of Long Island Backstory.
And then start stepping it up, start sending in complaints. But if you shoot your load right at the beginning, you got nowhere to go.
Another question.
So always step it up.
Is there such a thing as a friend of the court letter to the judge. Sometimes litigants feel like they're at the point where they're not getting anywhere, and they want to stop the process. They want to shake the attorney. They want to shake the judge up and say, wait, something hasn't been addressed. I mean, this happens.
Right. Well, listen, there's amicus briefs, friends of the court, and you can. And it depends.
How much of an effect do they have? Can they help
listen,
you in a case?
again, you're stepping it up. If you're at the point where you've lost, you're the designated loser. I know it, you know it, my lawyer knows it, you have nothing to lose. Some judges, I know Judge Lees looks at amicus briefs and will read them. Sometimes will even say, hey, whoever wrote that brief, I would like them to come in and question on it. So he does look at it. Some judges say, screw it, I throw it in the garbage. But writing letters can't hurt if you're already losing, right?
Well, your attorney advised that you should.
Now, listen, you can't always listen to your attorney and stuff like this.
agree.
You know,
I mean,
just like if you ask an attorney, do
would
you
it
want me to
most
come on
likely-
the show? No, don't come on the
I
show.
just said that in the last
Yeah,
show.
don't
For
expose
the
it.
most part, they're not going to be in favor of
Right,
that.
but that makes me nervous.
right?
Well, you know what? Well, sometimes it may not be a good idea, right? I mean, you have Judge Cheryl Joseph
Should
out
you let
here,
your senior
and she
attorney
just
see
gets
it within the
pissed
last
off
30 seconds?
no matter what you do. So it depends on the judge, and you have to know the judge. So I can't say send it. I can't say don't send it. Sometimes it works, just like filing a complaint against the judge. If the judge is a narcissist like Cheryl Joseph is, you know, out in here at Suffolk County Supreme Court, you can do whatever you want. She thinks I'm better than you, and you're not going to scare me with your letters. You're not going to scare me with your lawsuits. Some judges, you know, are a human being and they're like us. They want to be liked. They want to do the right thing. Sometimes they're just blinded by the system.
Gary, thanks a lot. You're a big help. Is it possible to win in family court?
Get into the air quotes for the win.
Great idea, great idea, and I hope that you've listened to this and used this as a form of reference for yourself or for anybody that you may love. You've been watching FIT TV, the program that brings you behind the scenes of our divorce culture. At FIT, we know you cannot get this information on your own, so we'll bring it to your TV every single week. My name is Chris DiMaggio. Thank you for watching FIT TV, and I'll see you again next week.